Okay, well, I'll go ahead and start us off as we are at that 10 o'clock mark. So welcome everyone. Thank you for joining us this morning for this webinar. It's titled Avoid Getting Burned, a summer briefing on international trade. So myself, my name is Camille Edwards, and I'm an attorney with Torres Trade Law. Myself and my colleague, Dawn Pierce, will be speaking today. And I'll kick us off and then I'll flip it over to Dawn. And I'm so sorry if you can hear sirens right now. There's something crazy going on outside on the street. So hopefully that's not coming through on the mic. But yeah, I'll be kicking us off. This webinar is really to provide you with an update of what's been going on since President Trump took office back in January. For those that are new to the international trade world, we have some kind of foundational aspects, some refreshers on the agencies that you may be hearing about and when you're reading the news or watching the news, and kind of some background knowledge that we'll offer too on the regulations, the statutes and the laws that are behind these trade developments that we've seen over the past 6 months. So if you're new to international trade, this is a great webinar to kind of get some background knowledge, get caught up. And if you're not new, this is a great way to see, make sure you haven't missed anything. There's been a lot going on since Trump took office. And this is kind of your refresher on everything that has been happening. So first, a little bit about our firm. We are an international trade and national security law firm. So we specialize in assisting clients with navigating U.S. export controls, import regulations, economic sanctions. We have also helped with foreign investment reviews by the Committee on Foreign Investment in the United States. And anything that's related to trade or national security as well, such as FCPA investigations, FCA, False Claims Act cases that have to do with customs, and we'll talk about that later too. But just kind of whatever is related to international trade, national security, that's what our firm deals in. So the agenda for today, I will first start off with providing a brief overview of the different agencies and the acronyms that you need to be aware of when you're reading the trade news. There's lots of different agencies that are involved in regulating international trade. And there's lots of different acronyms that are used for these agencies. So it's always good to get a refresher on the acronyms, the names that you need to know. That'll help make things more clear when you're receiving trade-related news. And then we'll move on and take a look at import regulation under Trump 2.0. So of course, we'll cover tariff updates, and we'll look into developments into import enforcement and compliance considerations. And then we'll kind of switch gears and we'll talk about economic sanctions updates. There's been some easing of the Syria sanctions, and then there's been kind of shifts in sanctions enforcement priorities under this new Trump administration. So we'll cover those developments. And finally, I'll give you a brief overview of kind of some background on U.S. export controls. So again, if you're new to the trade world, this is a helpful place to gain some of that foundational knowledge that you'll need. We'll talk about the America First trade policy and how that is impacting developments and changes in U.S. export controls. And we'll also touch on the increased focus on China as kind of an enforcement priority. And then I will be handing it off to Dawn, who will offer some more in-depth expert insights on compliance with U.S. export controls, due diligence considerations, and he's kind of going to end things on probably a more interesting subject than I have. So that'll be good to end with him there. And then at the very end, we'll save some time for questions if you have any. Throughout the webinar, feel free to put questions in the Q&A box on your screen. And we should be able to see those, and we'll save some time at the end to hopefully address any questions that come in. Okay, so starting off with an overview of the trade agencies the agencies that are involved in trade regulation in the United States. A key one is the Office of Foreign Assets Control, or OFAC, which is within the U.S. Department of Treasury. This is the agency that is responsible for the implementation and enforcement of U.S. economic sanctions. We also have U.S. Customs and Border Protection, CBP, or sometimes we just refer to it as Customs. This is the agency that's in charge of, collecting duties on U.S. imports, reviewing the shipments that come in, and protecting consumer safety within the United States in that regard by reviewing imports and regulating things at the border. We also have the Bureau of Industry and Security, or BIS, which operates under the U.S. Department of Commerce. This is an agency, one of the two primary export control agencies. BIS is primarily responsible for the enforcement of the Export Administration Regulations, the EAR. On the other side, where we are talking about more defense-related items, we have the Directorate of Defense Trade Controls, DDTC, which is within the U.S. Department of State. It's another export control regulatory agency, and BIS and DDTC kind of work together to regulate U.S. exports and protect U.S. national security. Finally, on the periphery, we kind of have the U.S. Census Bureau, which is primarily, in the trade world at least, responsible for enforcing the U.S. foreign trade regulations, which govern the requirements for reporting your imports and exports. And then also the Department of Justice, which plays a role in trade-related enforcement in the U.S. The DOJ collaborates with the different U.S. agencies that are primarily responsible for trade-related regulation, and they help to prosecute criminal violations of trade laws and also conduct investigations when necessary. So hopefully that gave you kind of a good refresher on the different agencies that we may be discussing throughout the webinar and that you're probably hearing about in the news. So switching gears to imports and developments here under the second Trump administration, of course, we have to discuss tariffs, which are arguably one of the hottest topics right now. So just to provide kind of an overview for you, President Trump has issued kind of unprecedented tariffs under a statute called the International Emergency Economic Powers Act. Try saying that 5 times fast. So for ease of reference, we call that IEEPA. And historically, tariffs have not been issued under this or pursuant to this authority. So that's why now tariffs are gaining a lot of traction in the news. It's kind of an interesting continuously developing aspect of import regulation. And so pursuant to his IEEPA authority, President Trump has implemented what he calls reciprocal tariffs. And these were the ones that were issued during Liberation Day on April 2nd, 2025. Currently, there is a baseline 10% tariff on most foreign origin imports. And I say most because there are some trade deals in the works, and if it's Canada, Mexico, and China, the reciprocal tariffs and how they stack with each other may be a little different. But just generally, for right now, there's a 10% baseline tariff on most imports. Now there is an annex of country-specific tariff rates that will be higher than 10%. I think Vietnam was like 46%. Another one was like 28%. And so these are set to go into place on July 9th, 2025. um, unless trade agreements are reached between President Trump and the leaders of these respective countries. So we're kind of waiting for news on that and to see how that plays out. Um, but that deadline is quickly approaching, so keep an eye out for changes in the reciprocal tariff rates. The other tariff action taken pursuant to President Trump's IEEPA authority are the fentanyl-related tariffs. These are imposed on imports from Canada, Mexico, and China, and they're a response to the national security threat posed by illicit imports of fentanyl into the United States. So currently, there's a 20% fentanyl tariff on Chinese goods and a 25% fentanyl tariff on Canadian and Mexico goods. Some additional tariff actions to take note of are the Section 301 tariffs. These were implemented under President Trump's first administration and continued under President Biden, and are currently still in place. Now, there have been exclusions from the Section 301 tariffs since they were first implemented, and since then, the exclusions have kind of dwindled and dwindled over the years. But for right now, there are still exclusions in place for a variety of goods imported from China. Most recently, these exclusions were set to expire on May 31st and were extended by the U.S. Trade Representative through the end of August. So we're kind of keeping an eye out for news there on whether these exclusions may be extended further. We don't expect them to be, but I think some importers are keeping that hope that they will be extended further. And it's possible that there are changes coming down the line as far as the scope and the applicability of Section 301 tariffs. But for now, they remain in place for a wide range of Chinese origin imports. And then another tariff action to be aware of are the Section 232 tariffs. These come as a result of investigations into the national security impacts of certain U.S. imports. So currently, ones to take note of are tariffs on steel and aluminum imports, and also tariffs on automobile and auto part imports from most foreign countries. These can also stack with different tariff actions. So when you're trying to figure out, is my product subject to this tariff action or this one, it's good to consult your internal or external legal counsel to kind of get an idea of the full extent of the tariffs on a product from a certain country, because the way that they stack can be different depending on the situation. And finally, on the import side, there's some trade deals. I'm sure you've probably heard about it in the news, and there's also been some judicial challenges to President Trump's authority to take certain tariff actions. So I think most recently, we've heard news about the US-UK trade deal. There was an executive order issued on June 17th implementing parts of the general terms agreed upon between the United States and the UK. The US and China are also negotiating a trade deal, which, according to third-party sources and reports, is apparently finished, but there's been no official announcement yet about what the specific terms of that deal are. But it is expected that tariffs on Chinese imports will remain at least 55% at a 55% rate. Other countries, Vietnam, India, Japan, and the EU are also currently negotiating, and I think everybody's trying to make a deal on tariffs before that July 9th increase in country-specific reciprocal tariff rates. The legal challenges to President Trump's IEEPA tariff actions could impact the long-term applicability of these tariffs. So it's just something to keep an eye on. Currently, the case is on appeal to the Federal Court of Appeals, and they are set to hear oral arguments in the consolidated cases on July 31st. So that's something to keep your eye on whether these tariffs will remain in place going forward. So in light of all these tariff actions and these developments, import compliance and enforcement have to change to keep up with these new compliance risks. So where we're seeing customs enforcement ramp up are in false country of origin claims, misclassification of imports, and undervaluation of goods. And these actions or schemes kind of increase as we see importers, brokers, suppliers try to mitigate the impacts of tariffs. And some of them are just, not doing it in a lawful way. So CBP is obviously well aware of that. They're going to ramp up scrutiny of shipments coming in, especially from China. And so it's good to take a moment now and make sure that your import compliance plans internally are up to date, that everyone is aware of import compliance requirements, so that you don't get caught in a compliance pitfall in the wake of the rapidly changing tariff environment. We also have seen an increase in forced labor violations and UFLPA enforcement, and we're seeing indication that there's going to be stricter scrutiny on supply chains that are tied to adversaries. So these are things where maybe you're importing a product that has come from one party in let's say China, but it's maybe had Russian inputs used or something from a foreign adversary that goes beyond that first tier of supplier. So we're seeing kind of an increase in scrutiny of supply chains beyond the first tier suppliers, which is indication that companies should be updating their import compliance plans and due diligence efforts to remain ahead of potential compliance traps. So switching gears here, we talked about imports. We're going to switch to sanctions updates. And just as a refresher, the U.S. agency responsible for implementing and enforcing economic sanctions is the Office of Foreign Assets Control, or OFAC. OFAC has roughly 38 different sanctions programs that it administers. And sanctions can be a variety of different types. So we can have country-based sanctions that are in place in targeting a country as a whole, like a comprehensive sanctions package. We can have list-based sanctions, which are blocking or asset freezing sanctions that are in place on specific entities or individuals that are listed on one of OFAC's lists. And there's also sectoral sanctions that target specific industries, such as the petroleum industry or military manufacturing equipment, those kinds of things. We mainly see sectoral sanctions or talk about them in relation to Russia. So one important update in the sanctions world are the easing of sanctions on Syria. So kind of in a surprise announcement on May 13th, 2025, President Trump announced his intent to ease Syrian sanctions, which is kind of a historic move because they've been subject to some of the most restrictive measures for years now. So on May 28th, and following this announcement, OFAC issued a General License 25 to authorize certain transactions that were historically sanctioned under this program. Transactions now authorized are certain new investments in Syria, providing certain services, dealing in or importing Syrian petroleum or petroleum products. U.S. financial institutions can also begin processing certain transactions with the Central Bank of Syria, and transactions with certain blocked parties that are now listed in an annex are allowed. So, whereas these parties were formerly subject to list-based sanctions, so they were listed on an OFAC list and you weren't supposed to be dealing with them, now parties that have been transferred to an annex are OFAC has given the go-ahead to transact with those identified parties. What's not changed and what's important to keep in mind is that if a party is still listed on OFAC's, let's say the Specially Designated Nationals list, the SDN list, their assets remain blocked, and those prohibitions on dealing with that party remain in place. So it's important to remain aware that listed parties, listed individuals and entities, you still need to be screening for them to ensure that they are not involved in the transaction. If they are, then those prohibitions are still in place despite the general easing of sanctions on Syria as a region. And under this new administration, we've also seen some shifting enforcement priorities when it comes to economic sanctions. So, of course, Russia remains an enforcement priority. However, as the situation develops between Russia and Ukraine, and as we see how the conflict and peace talks kind of shake out, we expect U.S. sanctions on Russia to reflect this in a way. So, either increasing as President Trump needs to add pressure on a party to act a certain way, or decreasing if the parties start to, move toward a successful peace negotiation. So we expect, changes to be coming within the next year or so to Russia-related sanctions. We've also seen some indication that the U.S. may begin to divert from sanctions programs that are in place in the EU and UK. Before, under President Biden's administration, the US, EU, and UK have attempted to align their sanctions on Russia so that it's kind of a multi-party effort in sanctions enforcement. We do expect President Trump to take a different approach later down the line, and so we may see some divergence there, which if you're a multinational company can create some compliance confusion as you are navigating the differences between these sanctions programs. So something to keep an eye on there. Venezuela sanctions, we've seen these ramp up as far as the restrictions go. There was some easing or relaxing of restrictions under the President Biden's administration. Towards the end, however, some licenses were not renewed, so restrictions increased, and Trump has continued with this trend. Kind of notably, on March 24th, an executive order was issued announcing that any country importing Venezuelan oil products will be subject to a 25% tariff rate on their exports to the U.S. So it's kind of a unusual tie between sanctions and tariff rates that we aren't used to seeing. And of course, as news has developed within the past week, an increased enforcement focus will be on Iran. It's currently subject to some of the most comprehensive sanctions. So we will expect to see an increase in SDN designations and other restrictive measures as that conflict develops. So something to keep an eye on there. And if you're operating within the Middle East or within that region, I would expect increased scrutiny of business dealings and shipments, and to kind of counteract or mitigate the risk there, being very careful with your denied party screening, your due diligence efforts is going to be crucial to staying ahead of the developing compliance risks. Also, a novel kind of enforcement priority under this new administration is the development and enforcement of sanctions against cartels and transnational criminal organizations, or TCOs. In general, combating the activities of these organizations is a big priority of this new Trump administration. So sanctions and the use of sanctions are obviously focused on combating the business dealings, the ability to continue to get funding and to involve other innocent entities per se, that's being targeted and trying to be mitigated by the Trump administration. So the designation of these transnational criminal organizations and cartels as sanctioned parties increases compliance risks for companies operating within that region that might have indirect or unknown ties to these entities through banks or shell companies. So it just reiterates the importance of maintaining strong compliance programs, upping your due diligence efforts, and conducting strong denied party screening so that you can recognize when a potential business partner or customer may present a sanctions risk. Okay, and shifting from sanctions to US export controls, just to provide some background for those that may be new to the trade world, there are kind of two major sets of export control regulations in the United States. Um, excuse me, one of them is the International Traffic in Arms Regulations, or the ITAR. These are enforced by DDTC on the state side. And then the other set of regulations is the Export Administration Regulations, or the EAR. These are enforced by BIS on the commerce side. So the ITAR are focused on the regulation of defense articles, technical data, and defense services. And we say, or we generally think about ITAR in relation to its control of military related goods. However, certain aircrafts, water vessels, chemicals, and other technology or types of advanced technologies can be controlled by the ITAR. So a compliance tip here is to, when you're classifying your product and trying to determine which set of regulations governs, it's always good to start with a review of the ITAR first to see if your product is referenced in those regulations and controlled there. If your product is not controlled by the ITAR, it will be controlled or subject to the jurisdiction of the EAR, which is mainly concerned with the regulation of dual use exports. So these are kind of military and commercial goods that are being exported from the US. So on the very first day President Trump took office, we've seen a kind of guided effort to update US export controls and US agencies' approaches to trade regulation. So I'm sure you probably all heard of the America First trade policy. Although it's been a few months, I think it's good to bring up again. And you can see here in the excerpt that's taken out from this policy that it does specifically focus on directing the Secretary of Commerce and respective agency heads to update export controls, incentivize compliance, and kind of update these regulations to better align with new developments in foreign policy objectives and address new risks that are developing. And I think it's important to hit on that China is a key enforcement priority, especially when it comes to US export controls. As opposed to, I guess, regulation of products or dealings with Russia that is more sanctions focused. The US's approach to regulating trade with China, it strongly relies on export controls and their enforcement. So key sectors that are targeted when it comes to trade with China are semiconductors, AI, and quantum computing. The U.S. utilizes export controls in these sectors to protect U.S. national security and the U.S.'s position as kind of a dominant power in the development and sale of these types of goods. So export controls can serve a variety of different foreign policy objectives in that regard. So we expect export controls, especially on China, to remain in place under President Trump and continue to be tightened depending on how negotiations with China on a trade deal pan out, as well as other countries within the region. There have been recent developments, again, about the U.S.-China trade deal. However, nothing official has been announced by the White House as of date, and so kind of waiting to see there on what this trade deal may entail. But reports have suggested that an easing of certain export controls on China may be a part of that deal. And since we are at 10:30, Dawn, I may pass it to you now because I think this is a good place to leave off since you were going to cover some BIS updates.
Excellent, sure thing. So let me throw the slide deck up here for you. We're going to dive a little bit deeper into the compliance side of U.S. export controls, and we're going to take a look at General Prohibition 10, which is, sounds kind of important, right? If we're, generally prohibiting you from doing something, it's probably good that you find out what that is. And we're going to talk a little bit about the due diligence that should go around your programs in general, regardless of whether the latest changes and the latest notifications from BIS are within your lane or not, and kind of take a broader look at some of the more specific information that BIS has been providing lately. You kind of know who we are already. I'm going to skip that for time's sake. We'll talk a little bit about General Prohibition 10. We'll then go over the latest BIS guidance that is intended for advanced semiconductors, but is generally applicable in many cases, as we'll go through. And we'll discuss some of the red flag indicators that BIS is calling out in these documents. And then we'll talk a little bit about some due diligence strategies for you to employ to keep yourself on the right side of the law, keep your IP protected, and more importantly, not support something like a weapons of mass destruction or missile technology program that you might not want to be involved in. So, what are the general prohibitions? Think of it as the 10 Commandments of the EAR. This is a distillation of basically the violations section of the EAR, and written in more of a thou shalt not motif. It describes certain activities like around exports, re-exports, transfers in country that you cannot engage in unless you have a license from the Bureau of Industry and Security or qualify for some license exception. Keep in mind that in many cases, those license exceptions are pretty powerful, exempt a lot of things, but you've got to plug in that end user information to make sure that you're still going to be viable in using those exemptions. So let's skip straight to General Prohibition 10. Knowledge that a violation can occur. Proceeding with a transaction with knowledge that a violation has occurred or is about to occur. So what's the realistic side of this? Like, where the rubber meets the road. What's knowledge? So there is a legal definition of knowledge, and there is a definition of knowledge that the Bureau of Industry and Security uses in both its administrative and criminal enforcement matters. If you know or should have known, in many cases, Commerce will assume that you knew. Now, administratively, it's an easy call to make because they only have to be more likely than not that you knew what you were doing was wrong to show that it's knowing. But that's not enough on the criminal side of this. For criminal investigations that might lead to prosecution, that prosecution requires much more than just that preponderance of the evidence. It requires proof beyond a reasonable doubt that you knew you were doing something wrong in this case, and you did it anyway. Now, the nice part about that for criminal investigators at BIS or other agencies that are enforcing export control laws is that you don't need to know that you were violating 15 CFR 736.2, which actually it's the general prohibition. It can't be used as the criminal violation. You have to go to the violation section for that. But you don't need to know the numbers. You don't need to know the chapter and verse. Some of the greatest cases were made on simple throwaway lines like, don't call it that, or customs will come get us, or we might get in a lot of trouble if we do this. That mens rea, the knowledge, the knowing, the mind knowing that what you're doing was wrong. Finding proof of that can be challenging, but you'd be surprised at what you find in people's emails. So this is General Prohibition 10. I like to say that this is a data-rich slide. And I do realize that that print is very small, and I think we're going to be able to get you these slides afterwards. But you can also just go straight to that site there, 15 CFR 736.2 B10, and be able to read it probably a little easier than on your, especially for those of you who are on a phone today. My apologies. These slides will all kind of look like this. So the reason we picked General Prohibition 10 to talk about is this guidance that came out on PRC, People's Republic of China, advanced computing and integrated circuit production. So you're all on notice now. If you're in this world dealing in advanced ICs or FPGAs or other technical articles, you probably already know all of this. But for those of you who are not, and you're not following these stories, let me give you a quick background on why this is a big deal. So specifically, BIS called out Huawei, but it is also targeting any other advanced node in integrated circuits that are being produced in China, because they suspect that the underlying technology, in some cases, even the underlying, some of these, the chips were manufactured using US technology. And in some cases, components may have been illicitly procured to stand up these lines to produce these ICs. Either way, all of those, specifically with regard to Huawei, all of those transactions required a license. And in BIS's estimation, none of them applied for or received one. So this basically taints everything that Huawei touches with one of these high-end Huawei chips. Now, these are the ones that were in the news a couple of months ago, where Huawei was bragging that they were able to make a 7-nanometer chip, and then there was a whole back and forth as to whether that chip really was 7 nanometers, or is it really being produced at the rates and with the low fail rate that they claim? Is it just government subsidy for a middling chip? Irrelevant. First of all, BIS still considers any semiconductor smaller than 14 nanometers or smaller as advanced, which my fellow nerds are giggling at right now. But also specifically the fact that information has come out both in the press and apparently in criminal investigations and administrative investigations that BIS is currently involved in, that there is a dual supply chain going on at Huawei, where if they can't get what they need through chip smuggling or more traditional export control related problems. They are using front companies to come into other companies outside of China to produce what they need to be able to make these chips. So, where does that leave you? Well, if you were planning on using a Huawei brand semiconductor in one of your projects, you're going to have to go get a license from BIS first for one of these chipsets that we mentioned here, the Ascend series. If you use these without BIS authorization, they can come down on you. And companies overseas have just as much exposure as companies in the United States. There's nothing stopping the Bureau of Industry and Security from showing up to do an end use verification overseas. Well, other than the fact that they're voluntary, so you could tell them to leave, but that would throw you on the unverified list just a little bit faster. And while they would not be able to, in many cases, put that habeas grabus on you and drag you away in handcuffs, if you like to travel, you might find yourself extradited from a country that will do that for the United States. So again, think before you utilize Huawei. And within those documents, there was some industry guidance to prevent the diversion of advanced computing integrated circuits. And red flags are great. I love red flags. I love the fact that we have made them much more specific than they were when I started as a rookie agent in the New York field office back in the 90s. Back then, it was a sheet of paper. There were about 20 of them. Don't ask questions if a small bakery is ordering a 5-axis CNC machine. Probably not necessary. But I do like how they have broken down in this guidance how these red flags affect the advanced computing industry. But we can still pull some great hints out of this for industries other than semiconductors. So for example, they called out a couple of red flags specific to business history. The customer has never received exports of advanced computing ICs, and now all of a sudden, after October of 2022, when these regs first started coming into place on advanced ICs, they suddenly wanted them. Now, granted, a company might be diversifying. They might see a need for these components in their own clients' supply chains and want to be able to serve them. This is where you ask questions. One of those questions should be, who's your end users? Now, in many cases, distributors have a real problem with sharing that data because they think you're going to cut them out of their transactions. This is actually something that many companies alleviate by putting language into their contracts that say that they have to provide this information, but that in return for having to provide that information, they will not go and loop the middleman out of the transaction. It's actually one of the most frustrating things that I saw when I was working as an export control officer overseas is when companies thought I was coming in there to do business intelligence for some other joker that's going to box them out of their sweet deal. And I would often say to them, well, first of all, I work for the government, and we don't share this information outside of government channels. And if we did, I'd end up in the same orange jumpsuit that all those jokers I put in jail ended up in. So, yeah, and I don't look good in orange. But I also felt like I needed to make it more personal for them to understand that taking a little bit of time to learn more about your client means you're probably going to be able to sell them more. So don't think that I'm here to do business intelligence on you. I'm here helping you to do business intelligence on your supply chains so that maybe you can make a little bit more money out there. You can buy a little bit more stuff and maybe buy a little bit more American stuff. Because I did work for the American Embassy in the commercial section. So of course I'm going to fly that flag. Customer received exports involving advanced computing ICs, but the number of them went up. And again, this can be applied to almost anything. If you are looking specifically at the Russia sanctions, there were companies that maybe got 10 or 15 shipments a year from a single source in, say, Turkey, and 40 or 50 from a source in Russia. And now all of a sudden, that Turkish source is ordering 100. Might be time to ask some questions. As many of you know, one of my favorite things is open source intelligence collection. I love the fact that you can sit at your computer and pull up fresh satellite imagery from all over the world, if you can afford it, because that those Planet subscriptions are expensive. But even without that, you can pull up satellite imagery and look at anything in the world. It's pretty cool, right? Physical address is a huge issue when we're talking about knowing what's going on. In this case, understanding that someone can put an address down anywhere on the planet into your online order database or in a request for quote, and most people will not think about the fact that you should probably go and verify it. I've had cases in the past where if they had just thrown the address into Google, the first result showed the connection to a company on the entity list. And now that BIS is actually using that address information on the entity list, whereas back in the day you had to have the specific name of the company, and now it's just any company located at this address on the entity list, that can be a problem. So just learning a little bit more about the physical address of a company. And the online presence is really important. I've said for years that the best way to learn what a company is actually doing in its domestic market is to look at its website in the native language. Again, and I hate to sound like a commercial for Google. I keep name checking them, but let's just say that all of the major web browsers have some sort of a translation feature. So what you should do is go to the address, go to that address with the .en or the English site, the English.com site, whatever, and go and read it. Then try to find that site in the native language. And many times that can be found, let's say if it's a Chinese company, as a .cn rather than .com, or but there will most likely be a domestic version of a company's overseas website. And if the tone changes from connecting customers worldwide to a vast variety of great technology to serving the PRC military for 30 years, you might want to think twice about that transaction you're about to do. Parties to the transaction. Sometimes we don't think about who they're using as a freight forwarder, or who they've listed as the ultimate end user in some cases. Sometimes they bury that information. Now, the good news is if you're scrutinizing your incoming orders or your business relationships on a regular basis, you'll notice new names. They'll stand out to you. And you should do a little digging on those. Especially, again, going back to addresses. If the physical address is co-located, you might have an issue. There's also kind of a website version of this, and you might want to go a little bit deeper on websites if you have some questions about a new client, or some questions about an old one, maybe changing allegiances. You might want to see if that web address is purchased by and registered to the same company. That's an easy way to see if companies are connected, if they're all from the same, if there's a single web source or a single source for the web addresses, same point of contact. Now, this could just be that they use the same contractor. It could just be happenstance. But again, it will give you data that you can use to put together good questions to ask the company and find out what the truth is. So, data centers and infrastructure as a service. Again, very niche field here. And I don't know if anyone on the call here is specifically working in these, but one of the interesting things about data centers is you should understand a lot about how they are doing business, because going back to the idea of looking at the parties to a transaction, data centers have a lot of external inputs that can be easily traced, much like supply chains. So if a company is coming in saying that they're running a data center, say in, oh, I don't know, Malaysia, we'll just pick a name out of a hat. And again, nerd friends are laughing. One of the things you might want to ask before you send that high value shipment is, where is the place? Because if they're setting up a data center in the southern part of Malaysia, which is trying to become the new place for high speed or high end data centers, or Cyberjaya up by Kuala Lumpur, kind of makes sense. Whereas if they're trying to drop it, out on the coast somewhere, where the infrastructure might not be able to provide the power required, and it gets hot in Malaysia. So in addition to just the power required to run the place, the power required to keep it at the low temperatures required for these systems to work could be challenging. So again, it leads you to the point where you can ask some questions and get some answers before you put yourself on the hook. So let's talk about some of these due diligence. You should evaluate both your current and new customers at some point. The new customers, think of it as onboarding. The tried and true that keep coming to your door, you should probably take a look at them every so often. How often? That's a decision you're going to have to make, and it's going to have to be based on your bandwidth, obviously, but also on how much information would you need to refresh? How much can you keep current on just with what you've got sitting in their file? But you should evaluate your customer data, especially if they're fairly new companies coming into you. Incorporation date after October of 2022 could indicate an attempt to set up a front company specifically to avoid the, at the time, new AI export controls. Looking at the ownership structure, seeing if there are anyone from those D5 countries, Iran or North Korea, or maybe take a look and see if there's connections to Chinese potential Chinese military end users, and understand what the end use and end user of anything you're shipping to a distributor or a supplier or even an end user themselves. Get them on record. Now, yes, they can lie to you. A lot of companies lie. They lie to the government too. Happens all the time. Sometimes the government doesn't even catch them. They just accept the lies and truth. So keep that in mind. But here's the part where you can kind of be a little proactive. Notify and certify. Let them know that the items you're shipping are subject to the EAR or ITAR, if we're talking, if we have any of those folks on the call, and require a license in the case of ITAR, or would likely require a license if there is a transfer or a re-export. Getting end user certifications for the parties to the transaction, a great move. For years, I said to companies, just take the BIS form, strip off the header, put it on your own letterhead, ask the same questions. Doesn't, in most cases, BIS doesn't even require an end user certification. But by you having that signature on there that someone went out and said, yeah, I'm going to use this and here's what I'm going to use it for. If that transaction does go sideways, you've got something you can hand to the investigators and say, go get them. Here's your knowledge. Here's that goes toward knowledge because I told them that they're supposed to get a license, and here's the end user certificate that said that they would. And if we're talking back about data centers, again, getting that written attestation that BIS wants, see if they're actually authorized to operate at the location. And that's a real big red flag if they haven't bothered to go and get the permits and they haven't started building, but all of a sudden they want 10,000 units of whatever it is you sell. Is the infrastructure in the area available to support the types of servers being exported in this case, or pretty much any kind of good or technology that your company might be exporting? Evaluate those data centers that are operating at greater than megawatts for AI training activity. And here's again where it really should understand what the company is planning on doing with your stuff, and they may be cagey about it. But when we're talking about larger scale operations like this, legitimate ones will probably tell you what they're planning on doing. And training activity, that can be significant, as we've seen with the advances in AI over the last few years. And of course, there's going to be a market for that. Understanding if that market exists in the place where they're planning on sending those components, that's important, and that can be a major red flag. Keep in mind that the reason BIS is worried about this is they don't want to see data centers being used to support weapons of mass destruction production or military intelligence end uses. So with that, we can open it up to questions. If anyone has one, I will open up that question box now. I didn't realize I didn't have it. Heard anything regarding NHSTA when an agent to import products not flagged for DT1 or DT2?
So, Don, I don't know if you have any more specific guidance on that one. This question is regarding the National Highway Traffic Safety Administration, and it's pretty in the weeds. As far as I know, there hasn't been any updated guidance on this issue. There's nothing out there to indicate that an agent would be required. That's kind of the most recent update I have on that.
All I know about this is that my son keeps going on and on and on about buying a Japanese domestic model sports car, and I just kind of roll my eyes.
Feel free to post any other questions. We'll have a couple minutes. Dawn, I think that was a great way to kind of wrap things up. And I think a lot of I know you were kind of export control, BIS focused there, but I think a lot of the compliance tips, the due diligence tips, transfer to sanctions compliance as well. And just general trade compliance, even on the import side, although it's kind of flipping your scope to your suppliers, asking suppliers to give you a certification that no forced labor was used in the supply chain, or that these products are coming from this one location and not from various third countries that could have foreign adversaries. That's also part of conducting your due diligence and staying ahead of any compliance pitfalls. Is that notify and certify? I liked that.
And frankly, legitimate companies will be glad to share most of this information. And it's not to say that if they're not sharing or don't want to share the information, they're problematic, but they're more likely to be problematic. So worth asking those questions. Get the best answers you can just to keep yourself safe.
All right, and it looks like we can wrap up if there's no other questions. Dawn has a link there to our advisory side where you can sign up for the newsletter. Our law firm also does a seasonal newsletter that will provide some more in-depth insights into trade developments in the international trade world. I also want to point out that we have a Torres Trump trade table on our law firm website as well that we update weekly. And it's a great way to kind of stay in the know on what's going on in the trade world, the all different types of executive actions, agency actions that are coming in. We're putting them all together in one place so that you don't have to go searching for updates when you need them. So I would check that out if you can. And this presentation has been recorded and will be posted on our website, and I believe sent out to all of the attendees. Yeah, thank you so much for joining us, and we hope this was helpful to you to give some background and then give you some compliance tips, due diligence tips, and get you in the know on all that's been going on in the trade world.